Now, Justice Jackson wrote a dissent to the opinion, which was joined by Justices Sotomayor and Kagan. The Civil Rights Act of 1871 was an exercise in grand ambition. It had to be. In the wake of the Civil War, the American South was consumed by a wave of terrorist violence designed to disenfranchise and intimidate the country's newly freed citizens and their allies. The threat was existential, not just for the newly liberated, but for democracy itself, and required bold intervention. It was precisely because the goals of the 1871 Act were so ambitious that those most committed to the structures it targeted, included many in South Carolina, opposed the measure so vehemently. The Civil Rights Act of 1871 was a grand ambition, but was only necessary because of the unwillingness of Southern states to enforce the supreme law of the land. While the threat was serious, that did not authorize the federal government to also violate the Constitution, which created it. A century and a half later, the project of stymieing one of the country's great civil rights laws continues. In this latest chapter, South Carolina urges our court to adopt a narrow and ahistoric reading of the 1871 Act's first section, which is codified today at 42 U.S.C. Section 1983. That venerable provision permits any citizen to obtain redress in federal court for the deprivation of any rights, privileges, or immunities secured by the Constitution and laws of the United States. South Carolina asks us to hollow out that provision so that the state can evade liability for violating the rights of its Medicaid recipients to choose their own doctors. The court abides South Carolina's request. I would not. For that reason, I respectfully dissent. Actually, South Carolina is not asking the court to hollow out the law, but abide by it. Under the Medicaid Act, states, and not the federal government, determine the qualifications for participation in their publicly funded healthcare system. The people of the state of South Carolina, through their representatives, have decided that those entities that provide abortions are disqualified from receiving public funds. Neither Planned Parenthood nor Julie Edwards have a right to direct public health care dollars. Therefore, there is no deprivation of rights to litigate under Section 1983. For a justice who appears so concerned about democracy itself, perhaps Justice Jackson should pay attention to the law rather than her political agenda. Because as a republic, the state of South Carolina has the right to direct their funds within the laws established by the people of the state and their representatives.